Hey folks, and welcome back to Contract Law. These are the videos for offer and acceptance, and this is video number 2. The first video had a little look at the whole notion of offer and acceptance, why we need it, what's it for, what does it do for us. And in this video we are going to be looking more closely at the whole concept of offer, okay, and all the principles that are associated with that. So let's have a look now at the offer. Okay, we all know pretty much what an offer is in lay terms. You know, somebody makes a proposal to you to do something. Okay, I'm going to make you an offer you can't refuse.
I'm going to make him an offer he can't refuse.
However, in legal terms, an offer that could potentially bind a party legally has to have a few hallmarks. It has to be a statement of terms. Okay, it has to propose that the offeror and the offeree do some stuff in exchange for each other. Okay, it has to be made by the offeror to the offeree. Only qualification to that really is if an authorized agent makes the offer to the offeree. Here it is again, that crossover with the other elements that are required for contract formation. It has to be accompanied by the intention to be legally and contractually bound by the offer. Okay, so if you've got those three things, you're more than likely away in terms of an offer having been made in a legal sense. It doesn't have to be in any particular format. It may be verbal, words spoken, words on the page. You could email someone. It could be by conduct. So there's an endless number of ways that an offer may be made. Essentially, it has to convey the statement of terms. It has to come from one party to the contract to the other, so offeror to offeree, and it has to be serious. There has to be that intention to create legal relations. What is not an offer? Well, three main groupings here of case law that have filtered down for us. Firstly, a mere supply of information is not an offer. Invitations to treat are usually not an offer, and mere puff is not an offer. So let's take those in turn. Mere supply of information. It's only going to be an offer capable of acceptance in legal terms if it is a firm promise to do or not do something. And that might ring some bells there from Carlisle's case where they were talking about a firm promise. Is this a real promise or not? What does that imply? A promise implies intention to create legal relations. So again, you see that intertwining of concepts here. So firm promise has that intent there. If a party is just simply saying, please tell me more, give me more information, then the other party provides it. That's not going to be an offer capable of acceptance, okay? And Harvey and Facey is just one example of that. So the inquiry was two-prong. Will you sell us bump hall pen? What's your lowest price? The response, interestingly, was nothing in relation to the first inquiry about whether they were prepared to sell, and lowest price for bump hall pen, £900. And then the purported purchaser nabbed in and said, yes, please, we agree to buy for that price. Now, was that an offer capable of acceptance? No. They had given the lowest price, they had communicated the lowest price, but they hadn't crucially indicated whether they were prepared to sell. And so it lacked that foundation of intention to be bound in this whole scenario. So obviously, no offer there, just a supply of information. Invitations to treat. Brilliant old English phrase. Treat is basically the equivalent to deal. So an invitation to treat is an invitation to start dealing, start negotiations. Come on, how about it? Why don't you make me an offer? Okay, so there's no intention at that point to be bound by anything that you're saying. It's really just, hey, what do you think about this generally? Okay, I love some of the equivalent words that some of the judges have referred to in terms of invitation to treat. An offer to chaffer is probably my personal favourite, but it all means the same thing. Just statements that are intended to get the ball rolling, or conduct that's intended to get the ball rolling. Obviously, because there's no intent to be bound, an invitation to treat can't be accepted. Okay, why is there this whole notion of invitations to treat? Because often a seller will commence this kind of dialogue with potential purchasers. What they want to do is drum up business, but they don't necessarily want to be strapped into having to be contractually bound to each person that comes up to them in order to deal. What they want to do is have that person make them offers which they can then accept or reject, because the reality is that they might not have enough stock to go around for all of the people that wish to deal with that particular seller. And in that case, you know, the seller would be, if an invitation to treat was actually an offer and you had a whole heap of acceptances, you ran out of stock, then you're going to be potentially breaching a whole heap of contracts where people have placed orders and you can't fill them. So what you need to do is have that step before offer, that is the negotiation phase, and that is where invitations to treat sit. Types of invitation to treat. Okay, we have various different streams of case law that have categorized the different ways that you can convey an invitation to treat. And again, you've got to bear in mind, these principles are really just rules of thumb. They are not hard and fast rules. So while I might go through here and say generally this is the case and generally that is the case, that is about as much certainty as we can get out of the guidance here, because it really will all come down to the particular language used by any particular invitation to treat, as to whether it succeeds and is just an invitation to treat, or whether in fact it is construed by a court later on, possibly, as a rigid true blue offer. Okay, a firm promise, if you will. So in Carlisle's case, and I'll be referring to that a few times today, it's probably the most famous hashtag fail in terms of saying, no, we never really intended this advertisement to be an offer. It was just, it was to drum up business. So what were the things that flagged to the court that this was actually an offer and not just an invitation to treat? Well, you'll probably be able to rattle them off, but it was the fact that they did see this firm promise. Okay, it wasn't just, hey, how about it, let's talk. It was, if you buy our product and you use it as instructed, and then you get the flu or a cold, we will pay you £100, clear as day. If you do this, I will do this. Firm promise. Again, it intersects with that notion of intention to create legal relations, and the fact also that they deposited £1,000 at a bank as virtual surety for their sincerity in the matter. So, but Carlisle is really the exception rather than the rule. And this is why things are only, these principles are only really guidelines. Most advertisements, by and large, will be just invitations to treat. And that's the same whether the invitation to treat is placed in a catalogue, newspapers, on the internet, in magazines. Same kind of treatment given by the courts to all of that conduct. Partridge and Crittenden is just one early example. In a periodical for British, obviously, periodical, we had an advertisement for Bramblefinch cocks and hens, 25 shillings each. Now, unfortunately, they were considered wild birds and you weren't allowed to offer them for sale or sell them. Someone bought one of these after seeing the ads. The question was Mr. Partridge, no pun intended, this is an ad about birds, was he guilty of offering a wild bird for sale. And they said, no, not at all. This was not an offer. This was simply an invitation to treat. The purchaser made the offer and Mr. Partridge accepted. So that is, generally speaking, the treatment that courts will give an invitation to treat in the form of an advertisement. Display of goods, again, much of the pragmatism coming through here in terms of the rationale for invitations to treat. And the Boots case was a very early 1952 case there, as you can see, of this newfangled thingy called a self-serve store. This was just about the time that supermarkets were starting to happen, and the whole notion of customer self-service was kind of taking off around the same time as Alati and Kruger, which you will cover in Contract B. And the question there was the pharmacy, in fact, infringing the prohibition on selling poisons without pharmaceutical supervision? And the court there said, no, they're not, because when the customer actually selects the goods for themselves, shock horror, off the shelf, they are not accepting the pharmacy's offer to sell. What's happening is the display of goods constitutes an invitation to treat. Hey, let's do business. You take the thing off the shelf, you put it in your basket, you go up to the cashier, and the customer then makes the offer to the cashier. Now, at that point, the pharmacist was there and they could say yay or nay to the transaction. And if they said fine, then payment would occur and the deal was concluded. So at that point, a contract was formed, and not earlier, when the customer took the item off the shelf and put it in their basket. So no breach of the prohibition there. So that's the display of goods issue. So auctions are the next type of invitation to treat we need to look at. You can split them into two broad groups. The cases, they'll deal with either auctions that have a set reserve or auctions that don't have a set reserve. For those that don't know what a reserve is, it's just the price that the seller sets at which they will be prepared to actually sell the item. Okay, so where an auction has a set reserve, the vendor has told the auctioneer, you know, anything under the $100, for example, I'm not going to sell. And if the bidding doesn't reach $100, the item will be passed in. Okay. Now, where you have an auction with a set reserve, generally speaking, they are just going to be invitations to treat. So the advertisement for the auction itself will be an invitation to treat. A call for bids by the auctioneer, again, will be an invitation to treat. How about it? Do you want to bid? It is a bid by the parties present and usually registered for the auction that will constitute the offer, and it's only when the auctioneer bangs down the hammer onto the gavel that the sale is actually completed and the vendor accepts the bidder's offer. Okay, so all invitations to treat right up until the bidder making their bid and then the hammer being knocked down. Auctions with no set reserve are a little less clear because you would think that as between the auctioneer and the bidder, there was a clearer indication that the item was going to be actually up for sale the moment that someone bid, because an auction without a reserve is basically the vendor saying, as long as someone bids on this, I'm going to actually sell it to them. So in Warlow and Harrison, we had a pony that was put up for sale at an auction without a reserve. So as long as someone bid, you know, the horse was going to get sold. Bidding happens and the plaintiff thinks, woohoo, I'm the highest bidder, I'm going to win this horse. And then all of a sudden the vendor comes in and makes a bid themselves for the horse. And the auctioneer does not knock the horse down to what effectively was the highest bona fide bidder. Okay, they knocked it down to the vendor themselves that come in with the final highest bid. And what the plaintiff argued was, hang on a minute, an auction without a reserve effectively constitutes a pledge by the auctioneer to the bidders that they will knock down that item to the highest bona fide bidder. Here, the vendor themselves bid. How is that a bona fide bid? And the court agreed, and they said, hang on a minute, the auctioneer should be liable. And the auctioneer was liable. So they breached that pledge to the bidders at the auction without a reserve that they would knock the item down to the highest bona fide bidder. In terms of more recent treatment, courts have kind of backed away from that a little bit. And in AGC and McWhirter's, you had a court saying, no, hang on a minute, we actually think that auctions without reserve are just a subset of auctions generally and don't really deserve any special treatment. So here, I guess, good example of the fact that these are only just guidelines, and it will often be a particular court with particular facts in front of them that will decide a certain way. So internet auctions really aren't treated any differently to normal auctions. The likes of eBay don't really change things a whole lot. Smythe and Thomas just shows us that principle. A rather large amount there, $150,000 was paid for a plane, and the ordinary auction principles were applied. This is probably a good time as any to stop the video now, and I think we'll chop this video in terms of offer. We will chop this video into 2 parts, and I will see you in the next video for part 3, and we will finish off our discussion on offer. Bye guys.